Who is responsible for Taiwan's defense?
Part 78. Taiwan is a sovereign independent nation.
Based on U.S. government's tacit acceptance of existing territorial claims and governance structure.
The contradictory stance of the U.S. government.
The U.S. government's acceptance, recognition, or concurrence with Republic of China, ROC, government's pronouncements in regard to sovereignty issues is commonly observed. By failing to react to ROC pronouncements of this type, the U.S. government effectively ignores the content of the Taiwan Relations Act, the Senate-ratified San Francisco Peace Treaty, the One China policy, relevant decisions in U.S. Supreme Court cases, the dictates of international law, various U.S. constitutional provisions, statements of executive branch officials, rules of international humanitarian law, etc.
Commonly heard ROC government rhetoric.
ROC government officials regularly make assertions of sovereignty over not only Formosa and the Pescadores, but also the Spratly Islands, Diao Utai Islands, Dongsha Islands, Paracel Islands, mainland China areas, etc.
Note: for ease of reference, we will refer to the above, over which the ROC asserts sovereignty, as the ROC claimed geographic areas.
If indeed ROC, Taiwan, is not a sovereign nation, as Department of State officials have stated on various occasions, why do such assertions of sovereignty go unchallenged and unrebutted by U.S. executive branch officials?
Underlying problems.
Looking back at the historical record, it appears that, primarily speaking, the differing interpretations of the ROC's legal status in Taiwan have arisen due to the lack of outspokenness and forthrightness of U.S. military officials, from Douglas MacArthur to the present.
In particular, the failure of U.S. officials to vigorously object to the announcement of
Taiwan Retrocession Day on October 25, 1945, which is commemorated by Taiwan government officials every year. The 1947 promulgation of the ROC Constitution in occupied Taiwan territory, and the continuing sovereignty claims over the above-mentioned ROC-claimed geographic areas, etc., have caused a majority of Taiwan people to conclude that the U.S. government recognizes the legitimacy of the ROC government structure in Taiwan in addition to its territorial claims,
military conscription, and military arms.
As far back as the World War I era, in the selective draft law cases, 1918, the U.S. Supreme Court justices found that military conscription policies must be based on national sovereignty. Such a decision is in complete agreement with Article 45 of the 1907 Hague Regulations.
If indeed ROC, Taiwan, is not a sovereign nation, as Department of State officials have stated on various occasions, what is the legal basis for military conscription in Taiwan?
It is worthy of mention that during the U.S. congressional review of the proposed Taiwan Relations Act in early 1979, Senator Jesse Helms pointed out the legal contradiction of providing military arms to the ROC authorities on Taiwan, while at the same time claiming that the ROC was a non-sovereign entity.
In other words, if the ROC is a non-sovereign entity, then the United States should not be supplying it with military arms.
ROC claims of sovereignty over mainland China areas.
Moreover, the failure of U.S. government officials to vigorously object to the definition of mainland area as referring to the territory of the Republic of China outside the Taiwan area in the Act governing relations between the people of the Taiwan area and the mainland area, originally promulgated July 31, 1992, has reinforced the impression of a majority of Taiwan people that the U.S. government recognizes the legitimacy of the ROC government structure in Taiwan in addition to its territorial claims over mainland China and other areas.
Who is One China? Accordingly, there are many people in Taiwan who believe that it is the Republic of China, which should be rightly recognized as the One China, which the U.S. government officials continually mention in their policy pronouncements.
Of course, some observers might argue that the ROC no longer maintains any territorial claims over mainland China. However, former President Ma Ying-jeou is on record as disagreeing with this type of interpretation. In October 2008, when being interviewed by Japanese media, President Ma stated that the ROC is an independent sovereign state and that mainland China is the territory of the ROC.
In the following days and weeks, no reports were carried in the local Taiwan or international media where U.S. government officials offered any rebuttals of President Ma's claims.
Further legal concerns.
More fundamental concerns regarding the legality of ROC claimed geographic areas can be found in Title 18 of the United States Code.
The military actions and the threats of the ROC's Ministry of National Defense in asserting sovereignty rights over the above-mentioned ROC-claimed geographic areas certainly involve violent acts or acts dangerous to human life, as a direct challenge to the territorial claims of other internationally recognized sovereign nations. They occur primarily outside the territorial jurisdiction of the United States, transcending U.S. national boundaries in terms of the means by which they are accomplished, and the persons they appear intended to intimidate or coerce. Historically, these actions have led to, and in the future can be expected to lead to, armed conflict between military forces.
U.S. executive branch officials should make a formal determination of whether the existence of ROC-claimed geographic areas and the pursuit of such territorial claims, which involve using force or engaging in acts of aggression, amount to multiple violations of 18 U.S.C. 2331 or other U.S. laws.
Conclusion.
As early as October 1954, Department of State publication stated,
"It may be noted that Japan never ceded sovereignty over Formosa and the pescadores to China. Japan renounced its own sovereignty but left the future title undefined. Thus the United States as principal victor of Japan has an unsatisfied interest in these former Japanese islands."
This was again confirmed in June 1956, in a Department of State memorandum, recording the content of a meeting between the Secretary of State and other officials, where the Secretary pointed out that,
"We might consider acting under the Japanese treaty since the U.S. has residual responsibility over all former Japanese territories."